So, how much compensation can I receive for a brain injury? Well, in a personal injury case, if you suffered injury, property damage, or any other kind of loss, as the plaintiff, you may seek compensation from whoever caused or contributed to those losses. And the legal term for this kind of compensation is damages. So, compensatory damages, broadly speaking, are broken down into general or special damages. Compensatory damages seek to reimburse or compensate an injured party for the harm they have suffered, and these kinds of damages are available in almost all injury cases, so including road traffic accidents or medical negligence. Punitive damages, on the other hand, are only awarded in a small number of cases. So punitive damages are in no way tied to the type of harm that a plaintiff has suffered, but are awarded to punish the wrongdoer for certain types of bad behaviour. Both punitive and compensatory damages are awarded directly to the injured party or the plaintiff. So there are different kinds of compensation available in a personal injury case, and the first category is special damages. And special damages compensate for monetary expenses incurred because of an injury. So they are unique to the individual victim, and they vary significantly from one party to the next. An award of special damages should make a victim whole for expenses incurred or for money lost due to the incident or accident that caused their injuries. Special damages cover any expense or loss related to the injury, and there's no real limit to the type of special damage claim that can be made or to the amount that an injured party can claim for. Some of the more common types of special damages would include, for example, loss of earnings, loss of future earnings, medical bills, cost of future care. And the second category of compensatory damages are general damages. So general damages compensate an individual for non-monetary damages incurred in an injury claim. So they are called general damages because they address harm that is typically or generally sustained in an injury. All types of personal injury victims are expected to have at least some general damages. And the most common type of general damages are, for example, for pain and suffering, mental anguish, or loss of consortium or companionship. So on the 6th of March earlier this year, so the 6th of March 2021, the personal injury guidelines were issued by the Judicial Council. Now, these guidelines seek to promote a better understanding of the principles governing personal injury awards. Interestingly, it begins by saying that the making of an award for general damages or pain and suffering is a somewhat artificial task because it involves a judge seeking to convert the pain and suffering of a given claimant into a monetary award, which he or she considers to be reasonable by way of compensation. That is a difficult task, and one which has historically led to judges making widely varying awards of damages in respect of relatively comparable injuries. So in relation to head injuries, the amounts recommended under general damages range from in or about 20,000 in minor cases to 500,000 in severe brain injury cases. And I would advise anyone to go and have a read of that document. The cost of future care and medical treatment make up most of the award, and it is extremely difficult to quantify. And where there is uncertainty in a case, the courts have approved interim awards. So each interim award stage involves submissions by the lawyers regarding the claimant's progress and the cost of treatment. So the future care cost element of a claim can be adjourned to allow time for the plaintiff's treatment to take effect, at which stage it would be hoped that a clearer picture of future care costs could be presented to the court. So in catastrophic brain injury cases, the costs of medical treatment and care are so high, any miscalculation could result in either an overpayment by the defendant or undercompensation of the plaintiff. And the courts have described the making of lump sum awards in catastrophic injury cases as fallible, unjust, and grossly outdated. And they have recommended that the approach of lump sums be abandoned. In 2019, there was a case of Jack Hegarty versus the HSC. The plaintiff, Jack, was a minor and a ward of court, and he had suffered hypoxic brain injury at birth, for which the defendants had admitted liability, and the matter was compromised and the terms of settlement were ruled, and an interim order was made for an interim payment of 1.6 million to include 400,000 in general damages. So I hope you found that video helpful. Thank you.